Good afternoon to all of you on the East Coast. It's the 14th of November, and it is starting to really feel like fall in New York City, and we have Thanksgiving around the corner. Lots of anticipation about that, certainly at least in my household. And we also have plenty to share with you on this morning's or this afternoon's program, as it were, depending where you're tuning in from. Lots to tell you about as the 45 minutes or so that we'll share together progresses. And so let me, by way of reviewing this agenda with you, let you know what we have on tap. To begin, I'll just spend a few moments with you, and then Seth Gilbertson is back. He is, of course, based in our Buffalo office and has a practice that involves higher education and labor. And Seth has a set of thoughts to share with you. The second part in our series concerning speech and implications for employers. So Seth will be addressing that right after this. Then we'll follow with Carl Dubel, who's back with us, second time on the program. And Carl will be addressing generally this tolling window for personal injuries that connects up with COVID. Then we'll have Emily Fallon, who will come on for a few moments, and she's going to look at the Commissioner of Education in New York State's determination around the use of biometric technology in schools. I'll come back at the end for a few closing remarks, a few updates, and we should have you out of here, as it were, again, in about 45 minutes. We appreciate, as always, your commitment to us and to this program. And we're glad, by way of your continuing participation, that you're showing us you find it valuable. So let me just introduce you first to Seth so that we can get the presentations going. And I remind you that Seth, who's been on our program many times over, is based in our Buffalo office, and he was also an attorney within higher education before coming over to Bond. He has government experience. He has a wide array of perspectives that essentially inform what he's about to address with us in his comments. So Seth, why don't you please turn on your camera and your mic, and I will turn the floor over to you for the second part in the series. Thank you, Seth, that Pete Jones commenced 2 weeks ago. Knowing that, of course, we're in a complicated environment where there is much in terms of speech that employers are contemplating, employers of all types and all backgrounds as well as configurations. Here at Bond, we're not alone. We actually just recently issued a statement of values concerning anti-Semitism and bigotry generally. And it's in that context, knowing that we are a part of this conversation with you, that we thought we would share our insights, what we've learned internally, and some of what we've seen from our clients who are grappling with some of these issues. So Seth, please go ahead and add some further thoughts to this dialogue. I look forward to learning.
Thanks, Gabe. And yeah, this is the second part of the sort of the conversation we're trying to construct around this issue. I'm going to try not to retread a lot of the same ground that that Pete did, but there will be likely some overlap as the issues are long-standing and unlikely to go anywhere, and many of the ways we address them are sort of tried and true, and we try not to we try to be consistent, and so some of the issues are going to be the same. I also want to sort of temper expectations here. We're not going to solve any national crisis, and we're probably not going to even solve all your individual problems in dealing with the kinds of crises or biases that you may confront either in your workplace or in your community. What we're going to try to do is create sort of a basic legal scaffolding around some of the decisions you're making, and give you some recommendations based on collective experience in an effort to try to help you navigate the diverse and digital workplace that an increasingly digital workplace that we're all working in. So the first sort of breakdown that I think is always needs to be addressed and considered, particularly when we're talking to such a large group of diverse employers, is the public versus private dichotomy, because it really matters a lot in this particular context. And I know Pete talked about this a little bit the other day, a couple weeks ago, but just to reiterate, because we hear it all the time, you'll hear, particularly on the private side, employers or employees saying that they have their free speech rights. And they do, they just don't have them necessarily vis-a-vis a public a private employer. On the public side, it's very different. The public employer, for the most part, is the government, and the First Amendment does apply. So that's sort of the first thing we often look at, and we're determining how we're going to address something, either whether it be through policy or through particular disciplinary measures. I'll talk about some areas where it doesn't apply in a minute, but it certainly limits, puts much greater limitations on a public employer's ability to respond to speech in really two ways. One, prior restraints, things that the employer can tell its employees not to say or not to do, in some cases in advance, and then what it can do in response to things that employees have said that it doesn't like, that may negatively reflect upon it, the employer, that is. Again, doesn't apply to private employers. That being said, there may be analogous policy and contractual limitations that do apply to private employers, and some of those also apply to public employers that may go beyond First Amendment protections and give additional protections to their employees, such as collective bargaining agreements, statements of mission values that they may be held to. Academic freedom is one of the big ones that I'm often working with in the higher ed space. Many institutions commit to principles of academic freedom, and that sort of almost brings in some First Amendment restrictions on their subsequent activities. And then procedural protections that may be in some place, like most often in an employee handbook, but also in other procedures that you may have promulgated as an organization. Next slide, please. So after that public versus private dichotomy, one of the other sort of buckets that we want to address, one of the two major ones here today, are speech by the employer. And I'm differentiating that from what we'll talk about next, which is speech by employees and how to respond to those. You want to be considering what you can say. Certainly, you can always communicate your mission and values. And I think that's sort of one way to say grounded and consistent with your statements. You can always reflect upon how certain issues are affecting your organization, whether that be your customers, your employees, other constituents such as students, your community. Ways that certainly that's something we've seen a lot of. You probably read a lot about it in the higher education and even primary education space. These days, you'll see law enforcement organizations, for instance, make statements about how certain things are affecting their operations. But really, that runs the gamut. You can always, it's sort of a safe place where I think most organizations can feel comfortable making statements. What can you say? Obviously, you can't make discriminatory statements or statements that have discriminatory impacts on your workforce or even other aspects of other constituencies that you may have. You can't say things that would restrict labor and organizing rights that may be protected under state or federal law. And those, as we know, those who are regular participants in these presentations will know, are expanding at a exponential rate what is protected under labor organizing rights these days. So it's something where you want to be careful and consult with counsel, certainly. Then the bigger question often is, what should you say? And I can't tell you what that is, but what I would suggest at this point, I guess, is to make sure that if the organization is the one speaking, or someone who sort of carries the weight of the organization, like a spokesperson or a CEO or somebody like that, that they are consulting appropriately within governance structures of the organization, whether that be a board of trustees or a cabinet. Certainly you want to be communicating with other important sort of thought leaders within your organization, like ideally legal counsel, your communications team, people like that, maybe even your human resources department. So it's not only what should you say, but who should sort of come together to determine what you should be saying. Next slide, please. So the second bucket that we really want to talk about here is responding to employee speech, and that's something that many employers are struggling with now. I think there is a sort of division here. It's much easier in almost every context, both public and private, to respond to and control employee speech that is made as an employee. So somebody who is speaking, if you're a customer service representative and you're talking to a customer on behalf of the organization has a lot of control over what that person says and how it can respond to what that person may say. It's very different when that individual is out there in the private space, the private sphere of their life, which the employer does have some interest in, the organization does have some interest in, both public and private, more so on the private side in this context, because there are pretty strict limitations on to what extent a public employer can restrain or respond to speech that's made in the private sphere of life of their employees. You can look back, I think on August 22nd, I did a public employee speech session at one of these Tuesday webinars. I know we've written some things on this in the past too. So if you explore around the bond website a little bit, or even if you want to write to me directly, I'm happy to provide some of that additional insight that's more specific to how public employers respond to private employee speech. But these are a few of sort of the groundings that we're going to look to are what are the effects on the organization and the workplace. Certainly, if it's speech that's discriminatory in some way, it's going to affect the individual's workplace and ability to do their job. If it's made publicly or has attracted negative publicity towards the organization by virtue of that individual's relationship with the organization, that's something we're going to have sort of greater, we as the employer are going to have greater leverage to respond to. If it affects their collegiality, their ability to get along with and work closely with their employees and effectively with their employees, that's going to give us a greater interest in how we respond and a greater ability to respond more forcefully to the damaging speech, particularly. Then there may be policy and contractual rights that affect how you can respond as an employer to employee speech. And usually those sort of fall into two categories. It's the content of the speech and the process by which you would respond. There may be content restrictions in what you can, we talked about a couple of them. On the public side, it may be things like matters of public concern that you have less ability to respond to. On the private and public side, you may have less ability to respond to statements and content that is related to labor organizing. And then on the procedural side, on the public side, due process is a big issue that you oftentimes are going to have to provide to an employee before you can do anything that's responsive to speech they may have engaged in. On the private side, there may be CBAs involved, handbook statements, things like that, that put limitations and provide sort of structures that you need to follow and make sure you're following fairly closely, probably with counsel, definitely with HR when you're responding to these kinds of issues. Next slide, please. I just want to briefly, the topic of this isn't really student speech, but I did just want to, I know we have a lot of educational sector employees out here, and we really do want to just differentiate. Again, you have the public-private differentiation. Oftentimes public educators are governed by the First Amendment in terms of what they can respond to student-wise. On the private side, there may be sort of very similar restrictions that are set forth in their code of conduct, particularly around procedures that are used when they're responding to student speech, but also the types of speech that they're responding to. Certainly, it is harder, and there is a higher bar generally for the kind of student speech or the kind of speech you can respond to on the student side versus the employee side. There's not the almost implied or direct implication that when a student speaks, they're speaking on behalf of the institution or the organization, as you have in the employment sphere. In the employment sphere, a lot of times you can sort of directly connect the employee speech back to an impact on the institution. That's less likely to be the case on the student side. Certainly, we want to be aiming to prevent harassment and true threats. Those are sort of some lodestars, things that you're going to always look towards as the kind of student speech that you're going to actually want to sort of respond to with more force than other types of speech. And then I always encourage people to think about it as they're going into this responsive stance when they're entering into the decision of whether or not to respond to particular student speech or something that students engage in. Are we taking an educational approach here? Is that our goal, or is this really a punitive response? And of course, ideally, even things that are violations of the code of conduct, we're looking at from an educational perspective. But I think when you're expelling or dismissing a student, it's much harder to say that's really has a educational goal rather than a punitive type of goal, or you want to remove an individual that may be problematic within the institutional for engaging in harassment behavior or something like that. So you want to think about that sort of divide and what your end goal is here as you enter into any kind of process by which you're going to address student speech. Next slide, please. And then again, based on sort of collective experience here, just a few sort of takeaways that I'd suggest you consider as you're thinking about these issues. One is you really want to take the long view. I think good policy is informed by current events, but it's not entirely defined by current events. You don't want to be stuck in the past, but you also don't want to be a prisoner of the moment, right? We want to kind of have a balance here where we're consistent as an organization, and we're not just playing whack-a-mole with everything that comes up. We're focusing on things that implicate the organization itself and its core mission, values, things that affect it, or things that it's much more likely to engage in both itself and respond to when employees are engaging in those types of that type of speech, those types of conversations. And then ultimately, I think you want to really be both for your institutional statements and particularly for employees, setting clear guidelines, guide rails around what is permissible. You want to give employees, I think generally, even private organizations that have a lot of leeway in how they respond to employee speech, still want to provide some balance between the rights of the individual, and I say rights because they may not be actual rights of the person, legal rights that the person has, particularly on the private side, but rights that they have as members of our society, as participants in civil discourse, etc. So you want to balance those rights with the rights of the organization and the needs of the organization to act responsibly, to project itself in the way that it chooses to uphold and promote its core mission and values. And then again, set those expectations. There are very few areas where I think myself as a lawyer anyway, would ever advise you to sort of push the envelope of policy making beyond where you may be able to enforce it. And I'm not saying you do that here, but what I would say is that there's a lot of value in setting a very high bar and clear expectations, even if maybe particularly on the public side, you may not ultimately be able to enforce those as strictly as you'd like to. I think setting those expectations very high, particularly when it comes to abiding by, supporting, and not violating the core mission and values of the institution in some of these ways. I think using language that's clear about that sets those expectations very high, and then we'll enforce those as we can. You work with counsel to do that, and certainly work with counsel when you're drafting these sort of policy statements as well. And that's it for me. Thank you.
Seth, thank you. Really appreciate the time you've taken to outline some of the core issues. And as I mentioned at the top of your comments, Seth, Bond recently took a look at some of these matters internally. And on the 10th, earlier this month, our management committee issued a statement against anti-Semitism and bigotry. And to your point, Seth, every organization is different, every business is unique. And we had that own internal searching in terms of how we wanted to be positioned as an expression of our values. And I'll just read one line from it, where, in a straightforward way, we indicate that Bond condemns anti-Semitism, Islamophobia, or bigotry and discrimination of any kind. That's a stance that as a firm we felt we wanted to take, and you as organizations may wish to put different concepts and content out there for public view. So if you have questions about how you frame that, what you might want to say, what you would prefer to refrain from saying, etc., as Seth pointed out, these are complicated times and complicated questions. And so please check in with counsel, and we are more than happy to be of help as a firm and as individual attorneys to you. So Seth, thank you so much for touching on these issues. And we will move on then to our next speaker for the afternoon. So that's Carl Dubel, who's with us from Rochester. Carl, I mentioned, is here for a second appearance on the program after fairly recently joining Bond. And Carl, as I noted in introducing Carl to an audience earlier, used to work down here in New York City and lived not far from our office, but has shifted back up to Rochester, where he's involved in litigation of a wide array of types. And one of the issues that he's come across is directly concerning COVID and the tolling window for personal injury cases. And so, Carl, we thought it would be a good time to update this group on what's new there, because of course, this program got its start focusing on COVID and what all of you as employers and others similarly situated needed to know. Those obligations haven't changed, and Carl is here to provide us with some more and fresh information. So Carl, please go right ahead. Thank you.
Awesome. Thank you, Gabe. Good afternoon, everyone. As you mentioned, my name is Carl Dubel, and I'm an associate here in the Rochester office. Today, I'm going to talk about the statute of limitations for personal injury claims and how it relates to that time period during 2020. The statute of limitations, to be fair, is not the most interesting topic, but it also is an incredibly important concept in litigation that could easily win or lose a case. So next slide, please. The statute of limitations are nothing more than just a time limit by which a plaintiff or an injured party has to bring a legal action in court. And really, after court, it is a policy judgment made by the legislature that balances two competing interests. On one hand, the legislature wants to be able to afford a plaintiff enough time to recover from their injury, consult with an attorney, and then decide, where do we want to bring this legal claim and how do we want to bring this legal claim. On the other hand, the statute of limitations protect defendants from stale claims that are years or even potentially decades old. If an injured party could wait indefinitely to bring their legal claim in court, evidence could disappear, witnesses could disappear or forget what happened, and that would allow one side to unfairly benefit from the passage of time. Next slide, please. So for personal injury cases, the statute of limitations in New York is 3 years from the accrual date, which when I say the accrual date, I mean the date that the injury occurred on, or the date that the person was injured. So for example, if a person slips and falls on a business's property today, November 14th, the accrual date would be today, and they would have 3 years, November 14th, 2026, to file a legal claim for that, to recover for that injury against the business or whoever other defendants they want to sue. If the injured party does not abide by this time frame, the court will dismiss their claim out of hand. Even if the injured party's claim is 100% meritorious, the court cannot afford the plaintiff any relief, and their claim will be dismissed. Next slide, please. So as everything with life, COVID-19 changed the world of statute of limitations. On March 20th, 2020, Governor Andrew Cuomo signed Executive Order 202.8. That executive order told the time limits for the commencement, filing, and service of any legal action. Through subsequent executive orders, Governor Cuomo extended this toll window all the way until November 3rd, 2020. What this effectively meant is that the statute of limitations clock, or the time limit to bring the claim, did not run during that time frame from when Governor Cuomo's orders were in effect. Next slide. Following Governor Cuomo's executive orders, of course, there was a significant amount of litigation about whether he told the statute of limitations or suspended the statute of limitations, because there's a pretty important difference. If this statute of limitations was suspended, the clock would continue to run, but if a claim was set to expire within the time frame from when his orders were in effect, the claim would survive its normal expiration date, and the injured party would have up until the executive orders expired to file their claim. So sometimes that could potentially be more than 3 years. Now, if this statute of limitations was told, that means the clock would completely stop during that time period. None of the days in the window would count towards the time limit. In that situation, if you had a injury that accrued inside the window, their 3-year limit would not even start until the executive orders had expired, giving them potentially much more than 3 years to file their claim. Next slide, please. So all 4 of the intermediate appellate courts in New York have held that Governor Cuomo's orders were toll, which, as I mentioned, meant that the clock was completely paused until the executive orders expired in November 2020. So if a person was injured in June of 2020, if COVID never happened, they would have their 3 years to file their claim in June of 2023. But because of Governor Cuomo's orders, the statute of limitations clock did not run until the tolling period ended. So although someone might have been injured in June of 2020, they really had more than 3 years to file and could have done so all the way up until November 4th, 2023. The Court of Appeals, which is the highest court in New York State, has not addressed this issue, but given the fact that all of the intermediate appellate courts have come out the same, it's probably unlikely that they would take a case on this issue, but still possible, of course. Next slide. Now, the inspiration behind my informational memo, which is on the FERS website, and this presentation is that we are now officially outside of that 3-year period from the end of the executive order window. That means that businesses and defendants no longer have to worry about personal injury claims that accrued as far back as March 2020, when Governor Cuomo first signed that executive order. All claims of personal injuries that accrued during the COVID tolling window are now likely time barred and outside of the statute of limitations and will be dismissed. Next slide. Of course, the example I'm using is a legal claim for a personal injury. Not all legal claims are considered the same, and some legal claims actually have much longer statute of limitations and time periods to file before they have to be brought in court. For that reason, if you have any questions or concerns about litigation that you or your business might be facing, it's best to either contact a bond attorney or the attorney that you regularly work with. Thank you for your time this afternoon.
Carl, thank you. That was very informative and further updated this group on some of those lingering dynamics relating to the pandemic, really important ones for businesses to pay heed to. And as you pointed out, what you presented on is also available in a written summary through our website for anyone who's interested in reading up. So let me turn to our next speaker for the afternoon then, please. And that's Emily Fallon, who's an associate based in our Garden City office, a stone's throw from here. And what Emily focuses on throughout her work is management side, labor and employment law. And in particular, there's an overlay of school law. For those of you who are familiar with our firm, we have a strong focus on school law, particularly in that Garden City office, and Emily is part of that group. And what Emily is here to talk about is the education determination concerning biotech in school. This is a really important update that we've wanted to bring onto the program for some time, and Emily has a few moments to share it with all of you now. So Emily, please go right ahead and let's get everybody up to speed.
Absolutely. Thank you, Gabe, and good afternoon, everyone. Kathy, if you could go to the next slide, please. So by way of background, biometric technology is any type of software that automatically recognizes an individual by way of their unique physical characteristics. So whether that be fingerprinting or facial recognition capabilities, which this determination focused on. So in essence, the New York State technology law has section 106B, which was put in effect in December of 2020, that put a moratorium on the use or purchase of any biometric technology in schools.
Emily, yes. I'm very sorry to interrupt, but there is a little bit of an audio issue. So if you are just able to stay where you are, I think that position is working well for the audio quality. When you turn your head, it mutes a bit. So I just wanted to let you know that, and I hope that we can proceed. Thanks.
Absolutely. Apologies about that. So as I was saying that, New York State Technology Law, Section 106B, put a moratorium on the use or purchase of any biometric technology until at least July 1, 2022, which has come and gone, or unless otherwise authorized by the Commissioner of Education, which brought us here today. So if you could go to the next slide, Kathy. So on September 27th of 2023, the New York State Commissioner of Education issued a determination stating two things. So first, the use of facial recognition technology in all schools is prohibited, and that includes both public, private, and charter schools, while the use of other biometric technology is permitted if a school district considers various factors, which I will get into throughout this presentation. Next slide, please. So as I said, the Commissioner of Education put a harsh ban on the use of facial recognition technology in schools. So in making this determination, the Commissioner considered a report put together by the New York State Office of Technology Services, which considered privacy implications of collecting, storing, and sharing biometric information that would be collected of students, teachers, school personnel, and the general public while they were on school property. And just the mere fact that this technology is so new and it's an area that really hasn't been studied by the legal profession or a lot of others, that, quite frankly. And it also identified extremely high rates of false positives, which creates liability both under civil rights and potential discrimination claims. And it found that facial recognition technology disproportionately had inaccurate readings of people of color, non-binary and transgender people, women, the elderly, and children. And anecdotally, we advise a school district here that was using facial recognition technology where a student was wearing a lot of face makeup and they couldn't identify the student with the facial recognition technology because they had a lot of makeup on. And it created a lot of First Amendment concerns because whether or not the student could express themselves through their makeup, where there could potentially be a security concern for the school if they were relying on this facial recognition technology to make sure that anyone who was not supposed to be in the building was not in the building. It also creates legal implications under FERPA, which is the Family Educational Rights and Privacy Act, whereas potentially storing and sharing what is considered an educational record should not be disclosed. Next slide, please. So schools that have already purchased and are using facial recognition technology that was put in place before December 20th of 2020 is still going to be covered using funds that were provided under the Smart School Bonds Act, but schools must discontinue and certify that such technology is not being used anymore with the Commissioner of Education. And any schools that have purchased this technology after December 20th of 2020 will not be reimbursed by the state using Smart School Bonds Act funds. Next slide, please. So as I said, the commissioner said that while facial recognition technology is banned, there are other permitted uses of biometric technology. Most commonly, we see fingerprint scanning for timekeeping purposes. So employees will come in, put their thumb on a scanner and clock in, clock out that way, just because it promotes efficiency and there's other considerations that are outweighed by potential privacy concerns. So districts maintain the ability to decide whether or not to use this identification technology, so long as they weigh privacy implications, the impact on civil rights, parental input, and, like I said, effectiveness. Next slide, please. So there's not a lot here as of yet, like I said, because this determination is so recent. So the practical impact is really dependent on its intended result. So like I mentioned, we most frequently see fingerprinting for employee timekeeping purposes, and those create different concerns versus whether or not such biometric technology is going to be used for school security. So districts should consider, if they intend to implement some type of biometric identification, that they review all privacy and security policies and collective bargaining agreements to avoid any risk of litigation, whether it be in the labor and employment context or in the sole focus of the education law.
Emily, thank you so much for providing that update. And one of the reasons that I was excited for you to share this information is because even though you were focusing in particular on education sector implications, clearly biometric technology is patent in many sectors, including among those outside of education represented among our participants here on the webinar. And so I think it's worthwhile for all of those tuning in to think about, whether your sector might be next, depending on what kind of public footing you may have, or otherwise, what the private sector type applications may be, because all of this is evolving, and our reliance on technology is only becoming more nuanced. And if you have questions, we of course encourage you to reach out to the bond attorneys with whom you have working relationships. So, Emily, thank you for coming back on the program, and I'm glad we were able to hear you loudly and clearly after that brief audio hiccup. So again, we appreciate your time. And so, Kathy, what I'm going to do now is cover a few items before we close. Before we move to questions, I'm just going to address legislative activity. What all of you likely remember is that 2 weeks ago, I came on and I talked about a variety of bill signings that have yet to happen, and we're still kind of in that posture. Among issues that remain open here in New York State as we move toward the end of the year include the Clean Slate Act, that Reparations Commission that I mentioned, the Grieving Families Act, which would have really interesting and profound implications for many businesses. The campaign finance standards that still have yet to be acted upon. Non-compete restrictions. Actually, we got a question in the chat about those just today, specifically bills Assembly 1278 and and Senate 3100A. Those aren't moving yet. Those haven't been delivered to the governor. And similarly, the LLC disclosures, which I had mentioned a couple of weeks ago, that's A 3484-A and S 995-B. And I mentioned those in passing because that is what has yet to move. However, there are a variety of bills that just in the last 24 hours were delivered to the governor. Delivery is a term of art in New York State. About 100 of them moved over to the governor's desk by way of that delivery. And that means that the governor has 10 days, not counting Sundays, to sign or veto those bills before they automatically become law. And so this is a really carefully coordinated dance that I've briefed you on before, this time previously in the fall of 22, certainly, where bills usually aren't delivered until the governor's staff requests them. The governor provides soft indications that she or her office is ready for them, because that 10-day clock is an important one for both the legislature and the governor. What happens, though, as we get to the end of the calendar year is that the rules change. Bills that aren't delivered or that the governor doesn't move on, even if they are delivered within the 10-day window before January 1, let's say something that's delivered on the 26th of December, hypothetically, those are handled differently. And they move into an automatic veto, essentially, after 30 days, rather than becoming law. So shifting from the default position of law being essentially what happens if the governor doesn't act, to veto being what the governor and the absence of action means, is an important difference. And so there's obviously a lot of scurrying about to time when bills get delivered, and we're in that process right now. And so some bills that got delivered, again, just in the last 24 hours, include, and I'm just reading from a list here that I have, some interesting ones. First is Assembly 1926A, which would require the Department of Health to publish certain information relating to home care service usage. Remember, Roger Bearden came on the program 2 weeks ago, and he was speaking about this bill and the broader context around tracking what's happening within the home health industry in New York State. So this is part of that. Then there's a bill by Assemblymember Dinowitz, or sponsored by, I should say, A 2190, which relates to remote conduct concerning the witnessing of healthcare proxies. it'll be interesting to track that. Certainly that has wide-ranging effects on the delivery of healthcare and the various forms of permissions that are necessary to ensure that care is consistent with the care recipient's wishes. There's another bill concerning the continuum of caregiving in the state. That's A 4275. This one is a biggie. We'll see what comes of it. There's A 4969, which again has been delivered, and that would create a state commission, temporary, but nonetheless a state commission, to study and investigate how to regulate artificial intelligence, robotics, and automation. Of course, this is coming off the heels of activity at the federal level. When Jessica Copeland was on the program a couple of weeks ago, she alluded to the executive order that President Biden had just issued in that space. It looks like New York State is trying to develop its own working group and essentially authorities around these complicated matters. Then you also have, if you go to A 5587, that deals with hospice, and there's a bill actually that affects things down here concerning Diwali as a school holiday. That one actually, to my knowledge, got signed. So Diwali is going to be a holiday that is reflected here for those who are connected with Hinduism or otherwise who observe that holiday. So those are just some of the matters that are percolating. And, we will keep track of those bills that I've mentioned and any that you would like for us to be monitoring. And I have a question in the chat, whether there's any update on COVID sick pay in New York. I'm assuming this is the question that we often receive around, whether what exists in statute has been shifted by way of legislation. There is no shift at this point. There's a bill that has been proffered by Senator Cooney, which I have briefed this group on before. It has not moved. It is not presently active. So we will keep all of you apprised if there is movement there, but it will take a legislative act if anything there is to change. And then there's another question that's just come through concerning the New York State exempt minimum salary threshold. We'll come back with a fuller presentation on that. I don't want to jump in on that question because I don't know the answer, to be candid, and but we'll make sure to have all of you better informed about that, in a future broadcast. But let me, with that background and a few moments that I've just spent on legislation, make the point that this is an area that at Bond we track closely. There are a few of us in our government practice, of which I participate, or in which I participate. Roger Bearden, who's presented, is also involved. Hermes Fernandez, other attorneys who track all of this on all of your behalf. And so just know that I'll continue to bring back updates for you as we learn more, particularly as New York State's legislative window for 2023 bill activity begins to close. And with that, Kathy, what I'm going to do is move to one more notice that I wanted to share with all of you. We have a webinar that matters to all of you who are in the healthcare provider space, particularly if you have Medicaid dollars that flow through your businesses. We know we have a bunch of you who tune in for whom that's a yes. And so we've had a webinar already where the Office of the Medicaid Inspector General came on, and that was back in September. We had the second in our series with the Office of the Medicaid Inspector General on Thursday afternoon. I'll be co-hosting that program. It's part of this multi-part series. We encourage you to click through and register if you haven't already. It's going to be focused on new and heightened compliance standards in New York State. I presented on these on the program going back now roughly 18 months when they were rumored but not yet effective, but here they are enforced now. And so the OMIG is going to be talking about them in a more detailed and focused way. So please register if you haven't already. And with all of that noted, I wanted to just provide you with the information on your speakers for today. You have Seth, Carl, and Emily's contact information. And of course, any of you can reach out to me. I'll be back with you in 2 weeks' time In the meanwhile, you'll have a chance to hear from Kristen Smith, who will be your host just before Thanksgiving. And let me take this opportunity to wish all of you a very happy Thanksgiving. And I look forward to closing out November with you. In the meanwhile, have a terrific afternoon.